Good morning, everyone. Welcome to WorkCover Queensland's Common Law webinar, where we will be discussing significant decisions on liability claims from the past financial year, and we'll unpack some learnings with a focus on health and safety training and compliance. My name is Tim Loos. I'm a lawyer at WorkCover Queensland, and I'll be your host today. Before we begin, we would like to acknowledge and pay our respects to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work and are speaking from today. We thank them and their elders past and present for their ongoing connection to land, waters, culture and community. Just some housekeeping for today. We will record this session and later send a link to the recording along with the slide pack and a short survey to gather your feedback. The recorded session will be uploaded to our YouTube channel, just WorkCover Queensland YouTube channel, and via socials. Please feel free to submit questions during the webinar using the questions panel to the top right of the screen. We'll do our best to answer your questions at the end of the webinar, and we will also be addressing some of the questions that were submitted prior at the registration phase. We're unable to answer any policy or claim specific questions, and we encourage you to contact your relationship manager if you have one, or reach out to a customer advisor handling a claim or claims for your business for more information if required. Finally, on the housekeeping, if you have any technical issues, please refer to the help information for GoToMeeting, which you will find at the bottom right hand of the screen. Right, I would now like to introduce you to today's guest presenter. It's presenter singular, I'm afraid, as one of our presenters was unexpectedly unable to attend. Here today is Angela Brookes, partner at law firm Hall Wilcox. Angela has over 12 years experience in workers' compensation, product liability and public liability matters. She acts on behalf of state, national and international insurers, self-insurers and Australian and international corporations. Angela provides advice, appears at conferences and in court on a wide range of matters with particular experience in workers' compensation claims. She's been involved in catastrophic, complex liability, high quantum and numerous fraud claims and has regularly acted in claims involving significant primary and secondary mental health injuries. Welcome, Angela. Our absent presenter, Monique Burr, a lawyer at Hall Wilcox, contributed to today's presentation. So thank you, Monique, and sorry you couldn't be here. Just before I hand over to Angela, I would just like to remind our listeners that any information provided, including in response to questions answered today by WorkCover or Hall Wilcox, is general information only and should not be construed as legal advice. That's all from me now. I will pass over to Angela to begin the presentation.
Thanks so much, Tim. The purpose of today's webinar is to discuss some of the recent case decisions that have been handed down by the courts in the last 12 months. Relevantly, from the 7 cases discussed today, all found the employer liable. Let's just take a step back and touch on the basics. Common law damages may be pursued if an injured worker is able to establish that their injury was caused by negligence on the part of their employer. That is to say, that the employer did something that resulted in the injury or failed to do something that would have avoided the injury. The test used to determine whether or not an employer has been negligent is set out in the Workers' Compensation and Rehabilitation Act. A simplified version of the test is this: whether the risk of injury was foreseeable and not insignificant, and if it was foreseeable, what precautions or reasonable steps did the employer take to guard against this risk of injury? Typically, a common law damages claim cannot be started until the statutory claim has been concluded. The injured worker's injury has to be deemed stable and stationary, and a notice of assessment has been issued. A common law claim is usually commenced by an injured worker by sending the employer and WorkCover a notice of claim for damages. This can occur up to 3 years from the date of injury. WorkCover defends common law damages claims on behalf of its employers, typically with the assistance of a panel law firm, such as Hall Wilcox. If the injured worker is able to establish the employer was negligent, that is, that the employer breached its duty of care owed to the injured worker, and this breach caused the injured worker may be entitled to damages, be in monetary amounts for general damages, payments for past and future economic loss, including loss of superannuation contributions, and payments to cover expenses, such as past and future medical, hospital, pharmaceutical, rehabilitation, domestic assistance and care expenses. Typically, the value of a common law damages claim is substantially higher than that of a statutory claim, and this is because of the inclusion of damages for past and future economic loss. WorkCover has processes in place to streamline the conduct of common law damages claims. But even so, a common law damages claim can usually be commenced at any time within the 3-year limitation period after the injury, meaning that cases come before the courts, as you'll see from the cases discussed today, often heard several years after the injury. Today, we will be taking you through some key case law decisions from 2022 and 2023 with a focus on training and enforcement and practical learnings for employers who owe a duty of care. We will focus on the employer's duty to take reasonable steps to provide a safe system of work. Let's look at the first case. Cup, Ferrith and A1 Custom Stainless and Kitchens. This case was heard by Judge Barlow in the Brisbane District Court, and the judgment was delivered in January last year. Here, the injured worker was employed as a metal sheet tradesman. Prior to the date of injury, a Z-shaped benchtop weighing around 120 kilos and requiring 4 to 5 workers was installed in a client premises. Following the installation, the employer was advised there were defects with the installation. On 18th of July 2016, the injured worker, a co-worker, and the director of the employer attended the site to repair the benchtop. Now, on the injured worker's evidence, when they arrived, the benchtop was in another room, not where it had been installed. He was directed by the employer representative to assist him to lift and move the benchtop to its original position, and he was then directed to lift one end of the benchtop with the employer representative and inspected it. After lifting and moving the benchtop, the injured worker says that he began to experience pain in his lumbar spine, and this continued through the second lift and for the remainder of the day. Later, when they were back at the employer's premises, the injured worker was polishing a bowl when a colleague said goodbye. The injured worker stood up, twisted, and waved goodbye, at which point he felt excruciating pain in his lower back. As a result, it was alleged the injured worker suffered substantial and debilitating pain in his lumbar spine, along with psychiatric injuries. It was the injured worker's position that the employer did not provide any training, instruction or documentation to him on safe manual handling of heavy objects, and it was the employer's workplace attitude that employees must just get it done, doesn't matter how you do it, just get it done. The employer denied any liability for the incident. It denied it should have known the work being performed by the injured worker was unreasonable or unsafe, contending the injured worker was an experienced sheet metal tradesman who had received oral training and instructions from the employer, and in any event had been fully trained in safe systems of work during his apprenticeship and in his earlier job roles. The employer's evidence was that the benchtop was where it had originally been installed. Therefore, the injured worker never lifted the benchtop. Rather, the employer's evidence was that the injury was caused when the injured worker twisted, waving goodbye to a colleague. The evidence of the injured worker and the employer were clearly opposed at trial as to whether the benchtop was moved. The employer had 2 witnesses provide evidence that the benchtop was where it was originally installed, and the injured worker never lifted it. So surely having 2 witnesses with the same version of events versus just the injured worker's version would have been great for the employer's case, wouldn't you think? Well, Judge Barlow found the injured worker to be a generally credible witness, and although the employer had 2 witnesses say the bench was where it was meant to be, the trouble with one of the witnesses was that it was his first day on the job with the employer and overall his recollection of the incident was not good. When considering the likely version of events, Judge Barlow had the benefit of expert medical opinion as to the nature and extent of the injury. The medical evidence suggested and supported that the injury was more consistent with heavy lifting rather than a twisting motion, and this was consistent with the injured worker's position of needing to lift and move that heavy bench top. Judge Barlow ultimately found the employer had breached its duty of care as the employer had failed to provide a safe system of work. This was because of the approximate weight of the bench top being 120 kilos, as well as it being in an irregular and unwieldy shape. There was a significant risk that handling the bench top would constitute a serious injury to the injured worker's back, and the obvious way to avoid the risk of injury from lifting and moving was to have more people or appropriate lifting equipment available. This was especially so when you consider the number of employees that were required for the original installation. After concluding that those incidences, the lifting of the bench top that is, was the cause of his severe back pain, and that the kitchen company was negligent in requiring the worker to perform the lifts without further manpower, Judge Barlow went on to assess damages. So what is the practical learning from this case? Well, there are many. An issue we often see in practice is an assumption that because a worker has a prior experience with an industry, they therefore are aware of the risk of working within that industry. Now, while that is true to an extent, it is critical for an employer to make sure they have satisfied themselves that the worker is A, capable, and B, can safely perform their duties. Risk assessments and having tools and equipment available for workers to safely carry out their work duties is paramount. This includes making sure, depending on your industry, that there are forklifts, trolleys, pallet jacks, or workers are trained in team lifting, and there are an adequate number of staff rostered on or available at the time. It is also really important to have a culture that focuses on safely carrying out work duties and encouraging your workers to take their duties and the risks associated with them seriously and making safety a priority. So let's turn to the next case. The next case is Northgard and Aldi Stalls, and it was heard by Judge Jarrow in the Brisbane District Court. The judgment was delivered late last year. Here, the injured worker was employed as a stall person, and part of their duties required the unloading and stacking of stock from pallets. On 28th of June 2019, the injured worker was unloading and stacking canned tomatoes. It was the injured worker's evidence that at the time of the incident she was holding 3 trays. Each tray contained 12 cans and weighed 5 kilos each. While performing the lift, she was bent over at the waist, and the carry was performed with the load held with outstretched arms below her waist. And she lost control of the lift, resulting in the cans falling and the injured worker suffering an injury to a lumbar spine. It was the injured worker's position that the employer had breached its duty of care by failing to adequately train her in safe manual handling techniques for an activity that carried with it a clear risk of injury, as there was never any limit imposed on what weight or number of items could safely be lifted at any one time. Safe manually handling practices were not enforced by management. Rather, there was an emphasis within the store on speed and completion of the task as opposed to safety, and it was the injured worker's evidence that the task was required to be completed within 20 minutes. The employer admitted that the injured worker was required to undertake the task as part of her work duties, but the employer denied that she was expected or required to complete the task in 20 minutes. It was the employer's evidence that there was no directive or instruction that the task was to be completed within that time frame. nor was the injured worker instructed, required or directed to lift 3 trays at any one time. Rather, the injured worker elected to lift those 3 trays. By doing so, the injured worker was in direct contravention of the theoretical and practical training provided to her. It was also the employer's position that the injured worker had been trained in safe manual handling, which included an instruction that items of more than 10 kilograms should be lifted by way of a team lift. So you would think on the employer's evidence it would be a slam dunk. Well, unfortunately it wasn't. The major focus of the evidence at trial centred around the extent to which employees were trained in manual handling techniques and the content of that training. Mr. Hutchinson's evidence, and he was led by the employer, so the employer's evidence, witness evidence, was that the injured worker was required to complete the new employee induction training modules, and that this consisted of 5 video modules that were then followed by a quiz, and one of those modules was on manual handling. The employer's witness evidence was that he recalled the injured worker located him following completion of the manual handling module, and that he demonstrated picking up a box and using the correct technique to the injured worker. The injured worker was also shown stretching posters located in the staff room, and the witness's evidence was that he actually provided training to the injured worker as to these stretches, and there was also a staff stretching sign-off sheet. When considering the content of the manual handling training module, Judge Jarrow noted, "At no point in the video was there any instruction about the maximum weight an employee could safely lift or maximum number of boxes or items an employee should carry. The lifting demonstration was of an employee lifting a box in the warehouse in a clearly staged scenario. So the demonstration, according to Judge Jarrow, bore limited resemblance to the types of products the injured worker was required to lift as part of her job. And the quiz at the end of the module only consisted of 3 simple questions, and it could not be considered a true test of an employee's knowledge of manual handling. There was only 2 possible answers to each question, with the correct containing a photograph of the instructor who had demonstrated the lifting technique in the video viewed only moments earlier. Ultimately, the injured worker's evidence was accepted over that of the employer's witness, being that the injured worker did not receive adequate manual handling training. The employer also led evidence that the injured worker participated in a buddy training system. Essentially, a new staff member would be placed with a buddy following completion of the induction modules, and that's what's happened here. Now, Judge Jarrow accepted, whilst perhaps there was an informal arrangement in place whereby for a short period of time a new staff member is observed with how they manually handled stock, Their Honour was not sufficiently confident a formal system was allocated. This was particularly so where there was no record of this occurring. Another aspect of the case was the expectation of the task being completed within 20 minutes. Judge Jarrow found that whilst there was no express written requirement to unload the pallet in 20 minutes, it was considered the actions of the employer through its management created an expectation to its employees that this task was to be completed within that time frame. Otherwise, they would not be meeting the standard expected of them. Judge Jarrow found there was a relevant risk of musculoskeletal injury from an employee manual handling products over 10 kilos. This was because the level of frequency and weight demonstrated a high likelihood of a serious physical injury if a worker were to adopt unsafe manual handling techniques. Judge Jarrow considered the employer should have had in place a safe system of work which included appropriate manual handling techniques, including the need to keep the load close to the body and have this enforced by members of the management team. The speed of completion of a task was not emphasised or made known by management, particularly for newer and inexperienced employees. A proper system of supervision so unsafe manual handling practices can be observed and corrected, and limitations on only 1 or 2 trays of canned tomatoes being carried at any one time, and the employer was found liable. So what are the practical learnings here? Ensure that you have adequate and appropriate training material. Ensure that the initial and refresher training are appropriate and that it is relevant for the injured workers and the duties that they are performing day in, day out. Ensure employees fully grasp and understand safety procedures and instructions, and avoid unreasonable time pressures on your workers. So let's look at the next case, Shuffer and Glendale. This case was heard by Judge Coker in the Brisbane District Court and was delivered late last year in December. Here, the injured worker was employed as a chef. Her work duties involved assisting with the preparation of lunch, afternoon tea and dinner for residents at an aged care facility. In doing so, she would need to load stainless steel food trays into steamer ovens. This was the task being carried out on the day of the injury. The trays would hold pans which contained food, and these pans were various dimensions and could be accommodated in the steel trays in various configurations. The trays would be loaded and unloaded from the steamer ovens. Whilst performing this task, the injured worker began to experience severe pain in her left shoulder, such that she could not carry on and had to leave work early. The injured worker sustained an aggravation of a left shoulder injury. The injured worker's position was that the employer breached its non-delegable duty to take reasonable care to avoid exposing her to unreasonable risks of injury and failed to provide or maintain a safe system at work. At trial, the injured worker's evidence as to her personal circumstances and nature of her work were mainly unchallenged. Of note was that the injured worker's height was at 157 centimetres tall. The specifications at trial for the brand of steam ovens stood at approximately 170 centimetres tall. There are 10 shelves with the top shelf height of approximately 155 centimetres. Now you would recall the injured worker's height is 157 centimetres, meaning the oven stood roughly 13 centimetres taller than the injured worker. Mr. Gill, who was a witness for the employer, was adamant that the injured worker was not responsible for loading and unloading of the ovens. However, when re-examined at trial, he indicated use of the oven was fluid. In other words, it was purely dependent on the menu needs and what people were doing. He conceded that the injured worker was in a better position to recall her roles and her duties on the day and what tasks she was required to perform. The injured worker provided evidence she had experienced some shoulder symptoms in the days leading up to the incident and had reported this to her supervisor. She had advised him she was having troubles with lifting. She also spoke to another worker about the same issue, however continued to work as she had previously done. The injured worker's evidence was the system of work of the employer required workers, such as herself, to perform manual tasks that were difficult, tiring, awkward, and characterised by repetitive movement and repetitive force. Now, the employer's position was as follows. They said that they had taken the following precautions. The duties that the injured worker was required to perform were varied, and the tasks described only constituted a small part of her overall duties as a qualified and experienced chef. The height of the racks were reasonable. The injured worker was not required to lift heavy trays continuously and repetitively at or above shoulder height, or place her left shoulder under any significant load. Manual handling was provided, duties were shared among 3 people, and the work was being performed at a reasonable pace. In assessing whether a breach of duty had occurred, Judge Coker assessed the relevant risk of injury as a worker repetitively manually handling heavy trays in and out of a steamer oven. Whether the employer had actual knowledge of the risk of injury to the injured worker's shoulder was actually not clear. The employer sought to rely on the fact the injured worker did not make full disclosure about a prior shoulder injury to the employer, and as such, the risk of her sustaining an injury was not foreseeable. To Judge Coker, this position of the employer ignored the inherent risk of the task. It was Judge Coker's view a risk assessment would have identified such issues. It was clear no such assessment was performed. An employer has the clear need to take precautions over and above the steps identified by the employer, according to Judge Coker. A failure to seek out knowledge of the risks constitutes a failure by an employer to take precautions in the exercise of reasonable care for the safety of its workers. The risk was apparent from the work being performed by the injured worker and should have been obvious. Carrying out a risk assessment was both reasonable and practical steps that were not expensive, difficult or inconvenient for the employer would have alleviated the risk of injury. The court concluded that a reasonable system of work would have contemplated that some workers may have a pre-existing shoulder degeneration and found there was a risk of shoulder injuries for workers moving trays weighing more than 3 kilos into the top racks of the steamer ovens, and that providing a step would have minimised the risk. So what are the practical learnings? It is critical to have in place documented and detailed risk assessments for the tasks that you are requiring your workers to perform. Tasks are suitable for a range of employees, but where they aren't, think about tools or equipment that can help minimise risk of injury. Respond to concerns around symptoms and consider modification of duties to minimise potential risk of injury. So let's look at another case, Canberra and Queensland Childcare Services. This matter was heard by Judge Horniman Wren in the Ipswich District Court and was delivered. The judgment was delivered last year. The injured worker was employed as a childcare worker with the employer. And on the 29th of August 2017, a co-worker was no longer able to commence at 6 a.m, and so the injured worker was asked to cover that co-worker. The injured worker arrived at 5:30 a.m. in preparation for the day's work. It was said that in some instances, parents would arrive from around 6:05 a.m, so its usual practice was to have the activity yards set up before the parents arrived. The designated group leader arrived at 5:45 and instructed the injured worker to set up the activity yard in the senior kindy area while they set up another kindy area. This was a departure from the usual practice of 2 staff members engaged in setting up the work area together. The items for the activity yard were stored in a shed. At the time of the incident, the injured worker stepped backwards out of the shed. As she did so, she stepped on a Lego block that had landed on the grassed area. Now, it was the injured worker's evidence that she was in the process of dragging out a rectangular A-frame alone and under pressure at the request of her colleague who was late to arrive, that the incident occurred early in the morning and it was notably still dark at that time. A regular overhead light on the building face was of poor quality and did not provide any adequate light into the shed. And the internal light in the shed did not operate at the time because the switch was defective. Now, the injured worker sustained injury to her right ankle and suffered an adjustment disorder with depressed mood. As she stepped on the Lego block and rolled her ankle whilst removing the A-frame obstacle course from a storage shed. The injured worker's position was that the employer breached its duty of care to provide a workplace free of significant and foreseeable risks of injury. The employer denied the allegations and made multiple attempts to discredit the injured worker's recollection of the incident. There was a factual dispute as to how the incident occurred, and the court ultimately held that the employer breached its duty due to a fact finding made by the judge that the block was already on the floor of the shed from the night before due to the employee staff failure to properly pack the shed in accordance with its policy or system in place to do so. The court and the judge considered that whilst there were lighting issues relevant to this matter and the lighting inside the shed was defective, the lighting issues were actually irrelevant because the foreseeable risk was actually the untidy shed, and that the lighting was an additional or alternate source of risk in the circumstances. So let's look at the practical learnings with respect to this case. Good record keeping. It is critical to keep accurate, detailed and contemporaneous reporting of incidences, and this is included when a WorkCover claim is lodged at the statutory level. As touched on earlier, by the time a common law damages claim has been lodged, it may be anywhere between 1 to 3 years since the incident, and important details may be lost to time. There was a procedure in this case, a closing checklist that needed to be completed and signed off on. It is really important to ensure that these aren't just being treated as a tick and flick document. If a certain task is required to be done, it should be done, and it should be done to a standard that is expected. A simple and inexpensive system the employer could have had in place here was conducting a routine audit every few days or every few weeks by selecting a completed closing checklist from the night before, and as they are getting the centre open, set up a cross-check that the items were done. Where they aren't being done, correction of the behaviour can be taken and timely reminders sent out to staff of expectations. Timely responses to maintenance issues. If there is a maintenance issue that is awaiting to be fixed, it is critical to communicate this to your staff. A simple company-wide email, simple as, "Hi, we are aware of an issue that a light is not working inside a shed. We are working to get it repaired. In the meantime, please take extra care when you're entering the shed. It is still dark. Please use an alternate light," may have assisted in the circumstances in the present case. This case highlights the issue to workers. It notes what action is being taken, and it provides workers with a control measure to minimise a risk of injury. It doesn't fully extinguish the risk, but it demonstrates a reasonable response on the part of the employer. Now let's look at Redoc and ST&T Pty Limited. This matter was heard before Judge Jackson in the Supreme Court, and the decision was handed down in February last year. Here, the injured worker, a concrete delivery driver, suffered a left wrist and secondary psychiatric injury. Her employer owned and maintained the truck she was driving. However, at the time, she was placed with Boral, who provided her with day-to-day instructions. Just before her injury, the injured worker had reported to Boral that the swivel chute on her truck was stiff and hard to move. Boral's batching manager inspected the chute, applied some grease, observed that it was still stiff, but requested that she perform another delivery in any event. The injured worker was injured whilst performing that further delivery. Now, the employer's evidence in this case was that the injured worker was provided induction training, and it required the injured worker to sign a register recording she was provided the induction. The induction of the injured worker entailed orally going through instructions on a printed induction document and giving a copy to the injured worker. Of note in the instruction document was the following. Safety. If you feel something is unsafe, do not proceed. Incident reporting. If you are involved in an incident or accident during your workday, you must inform the employer immediately. We will inform Borrell's management of the incident and let you know how to proceed. Also in the induction document was pre-start. If there are any issues with your truck, report them to the employer immediately. The injured worker's case was she did not recall particular instruction given to her to report all issues to her supervisor first before proceeding further. Her recollection, perhaps informed from previous experience in driving concrete delivery trucks, was to report issues to the batching line operator. In this case, that was Borrell, and that is what she did. The injured worker's evidence was she did not recall the suggested instructions on the document, nor being given a copy of that document. In any event, the injured worker's evidence was if she was given a copy of that document, it was inadequate, as it depended on the injured worker forming a view as to safety issues for which she was not qualified or trained to assess. Borrell was also found liable in this particular case on the basis that it was Borrell's batcher who had no mechanical experience, and his actions of greasing the chute could not have made the chute any easier to move. Further, he had required the injured worker to undertake the further delivery after she had already put him on notice of issues using the chute. But the employer was also held to have breached its duty of care to the injured worker, as its instructions were not clear as to who the injured worker should contact if she had an issue with the truck. The instructions were not clear and therefore could not be adequately followed. So practical learnings here. It is critical to have clear procedures and a clear understanding on the part of your workers as to the order of things. Appropriate tools to make decisions. If you expect your workers to make judgment calls as to safety and risk, they need to be equipped with the tools to be able to adequately do so. Make sure where procedures are documented that these have been given to your workers and you've actually gone through it with them. If it is important, make sure it is available. An injury is an incident and needs to be reported. Too often we see situations where an employee is injured or experiences symptoms, but they don't report it because the way in which they were injured or the symptoms appear or the symptoms appearing don't necessarily reflect an incident or accident. But early reporting allows for earlier interventions, such as work limitations if it's needed, or inspecting the plant and equipment. Let's look at the second last case, Wilcox and Sunshine Coast Hospital and Health Services. The injured worker was a patient support assistant and was working a night shift with a co-worker. The co-worker, who was also an employee of Sunshine Coast Hospital and Health Services, was placing a standard mattress on a bed that he was to deliver to a ward. The injured worker intervened in what the co-worker was doing, and ultimately her left arm got caught between the mattress and the bed and she suffered injury. Relevantly, in this case, the co-worker's evidence was that he in fact did not request assistance from the injured worker, and in fact the injured worker pressed to offer him assistance, which he refused, and he had no reason to believe that the injured worker would have attempted to assist in any event in the circumstances. So what are the practical learnings here? Well, this is a difficult one to discuss practical learnings because ultimately the case turned on the evidence of the co-worker, so the employer witness. What it does do, it highlights again the importance of contemporaneous reporting and ensuring an investigation is undertaken at the beginning of a claim. Remembering that this injury occurred in 2017 and a decision was only handed down last year. That's 5 years in between the date of incident, not only the date of incident, but also the common law claim. Another practical learning is, in this situation, the injured worker's conduct was determined as interventionist and unnecessary, warranting a significant reduction for contributory negligence. Ultimately, a court accepted a 25% reduction for contributory negligence. In these particular matters, employers need to be mindful that there just needs to be more than mere advertence and inattention and misjudgment. The final case that I wanted to have a chat to you about today is the case of Mason in the state of Queensland. This is an unusual case where the injured worker sustained a physical injury. However, the claim that went before the courts was for a secondary psychological injury caused by events that occurred following an assault. Here, the employer was found vicariously liable for the supervisor's intentional unlawful assault on the team member. This matter was heard before Judge Barlow in the Brisbane District Court, and this was a very recent decision that deals with a number of issues faced by employers and was handed down only last month. Here, the injured worker was employed as a correctional custodian officer with the employer. On the 22nd of January 2017, the injured worker was physically assaulted by his immediate supervisor in the context of a disagreement regarding a particular prisoner. Following the punch, the supervisor turned to his co-workers who were present and made comments about having confronted the injured worker and that he did not want to have to do it to anyone else. The injured worker at the time was uncertain as to what to do, and he spoke to another security guard. The injured worker was determined to try and speak to his supervisor later in the shift, but was unable to do so, and he then had several scheduled days off. Upon return to work, the injured worker was approached by the section manager, advising that they were aware of the incident and requested that the injured worker make a report. The injured worker did make a report about the assault that the supervisor made on him. Now, the injured worker does not claim physical injuries as a consequence of the assault by his supervisor. What he does claim is that his psychological injury was initiated by the assault and was also caused by the events at work which followed. Ultimately, his claim is characterised as being that for a month following his report of the assault, he was subjected to reprisals by staff, including the supervisor, and he was not provided with support in this regard. 1 month after the original assault, the injured worker arrived to work and found he was rostered on with the offending supervisor. He contacted his acting manager and informed them of the incident and that he was uncomfortable, and he was redeployed to another part of the facility. The injured worker was subjected to reprisals by other staff members, including the offending supervisor, and he was often asked during this month period why he was dobbing in the supervisor. The injured worker was told by a co-worker that the supervisor was going around talking about it and that the injured worker should be a bit more careful around the place. The injured worker has suffered a psychological injury as a result of the events following the assault, and it was the injured worker's position that the employer breached its duty of care for failing to discipline the supervisor, investigate the incident, enforce the code of conduct, provide the injured worker with support in his employment, provide all employees with appropriate training and education on the issue of appropriate conduct within the workplace, and ensure reasonable steps are taken so supervisors are responsible for making sure employees are following policies and procedures. The injured worker's view was that the employer should have avoided exposing him to employee behaviours and workplace circumstances, and this created a foreseeable risk of injury. Now, the employer denied any liability for the injury and argued that the injured worker's evidence of being subjected to harassment by colleagues was improbable because of the inherent risk of such officers facing disciplinary action if they were caught. The employer argued that any act or violence or threatening behaviour by the supervisor involved a criminal act and so was not foreseeable. A reasonable person in the position of the employer was not required to take any precautions to train or instruct employees, including the supervisor, not to commit a criminal offence or act, and any disciplinary action of the supervisor after the event would not have prevented such an event from occurring. Judge Long swiftly dismissed this argument, finding that the very risk of such behaviour, particularly in the workplace, underlined the acknowledged policies of the employer requiring the support and protections of persons such as the injured worker. It was determined by the court the wrongful act was not simply an emotional outburst as between two employees, but rather it was a wrongful form of management of a subordinate by a supervisor, or alternatively, a supervisor exercising their authority vested in them by the employer in an unreasonable way. As a public organisation, the employer had a legislative requirement to have a policy in place as to the protection and support to be provided to a person who makes a public interest disclosure. Accordingly, and from that point, when the injured worker indicated his concern, the employer was under a duty to take reasonable care to protect the injured worker from such behaviour and to support him so it did not lead to a perception he was being isolated and unsupported in the workplace. The incident was also referred to the Internal Ethical Standards Unit of the employer, and for which the employer had its own policy in respect to providing support. In terms of the injured worker's psychological injury, where defendant, and I should say where the employer has been put on notice as to the potential risk of psychiatric harm, the question becomes, what did the employer fail to do to protect against the incidences of such harm? And in this case, the employer failed to adhere to its policies to offer protection and support to the injured worker and was held vicariously liable for the actions of the supervisor for unlawful assault. So the practical learnings with respect to this case is this: take allegations from your workers seriously. Clear procedures are to be followed by management in the event of concerns between workers. Clear training and instruction as to reasonable management is really important, and appropriate support framework. And what all these cases have shown today are that courts are saying it's just not enough that we have systems in place and we provide training. It is important that as an employer, you have considered all types of tasks that you will require your employees to perform and the risks associated with carrying out those tasks, and that you make sure unreasonable pressure isn't being put on workers so that they can safely carry out their tasks. And this includes making sure your managers and supervisors aren't creating an environment where workers feel they have to take shortcuts in order to avoid being penalised or disciplined. And finally, if you do have systems of work in place, make sure they're adequate and critically make sure they're enforced.
Thank you, Angela. That was terrific, and then really good practical learnings for employers. So we've got some questions that we took at the registration phase, and we've managed to put them up on the slide. So I think that first question there is a really good way of continuing your summary conclusions on the common thread amongst these court decisions. So the first question there is some more details about what makes a defendable case that might be run to court rather than settled in pre-proceedings?
No, that's an excellent question, and I really think it's important to note that the standard of care owed to a worker by an employer is just so high, so it doesn't take much for the standard not to have been reached. And so there are only a small portion of claims that are defendable on liability. From a liability perspective, a defendable claim is one where an employer has not only designed, but also enforced a safe system of work. And we really look at the following factors: the adequacy of the precautions taken, including how the task was meant to be performed. Was there a procedure or system in place, appropriate training or instruction relevant to the task in question, whether appropriate assistance and equipment was provided, whether the procedure or system is documented or can otherwise be established by admissible evidence, whether any prior issues or complaints had been adequately addressed, whether there is evidence that any system was actually followed on a day-to-day basis. If you can prove all that, if you can establish all that, and if you've got witnesses that can be put on trial on the stand and be able to testify that that injured worker was trained in the system of work and that system of work was enforced, then that becomes a more defendable case on liability. But as I said on the outset, Tim, the standard of care owed to a worker by an employer is just so high that it just doesn't take much for a court to simply say that that standard had not been reached.
And of course, we're a model litigant, so it has to be a strong position on liability for us to press the point. Excellent. Right. Well, the second question up there is, how does a sound rehabilitation return to work program, safety leadership and improving safety culture assist in minimising common law damages? I suppose you've touched on all this sort of stuff in the course of the presentation, but would you like to touch on that a bit
Yeah,
more?
absolutely. I think first and foremost, what it does do, it actually prevents the common law claims just from the outset. So when we see sound rehabilitation and a sound return to work program and safety culture that's been facilitated, assisted and embraced in the statutory stage of the claim, it is more unlikely for an injured worker to actually proceed with a common law claim. So we actually don't even see those claims at first instance. But when we do see them, what we do see at the common law stage is that good and sound rehabilitation and return to work assistance actually assists employers in defending the claim from a quantum perspective, so a damages perspective. Of course, an injured worker who has returned to work and say has received clearance from doctors has a material impact on the value of the claim. It reduces economic loss.
Excellent. Question 3 is probably a big burning question for a lot of employers. It's to do with work from home injuries. The question gets a bit specific there in terms of ergonomic equipment, but I suppose, can you speak to, pardon me, perhaps some cases you've seen on work from home injuries and the employer's duty of care for work from home injury?
Yeah, absolutely. Look, the answer to the first part of that question, what's happening at common law for work from home injuries, the answer is not much at the moment. What we are seeing are some statutory claims that have come through with work from home injuries. I think it's important to note that if a worker is allowed to work from home, whether that's optional or mandatory, then the home is actually a workplace. So a worker is owed that same duty of care. The employer must satisfy itself they have provided a safe work environment as if that worker was working in the office. The standard isn't different. So there is no strict requirement to provide physical ergonomic equipment to workers, but an employer has the primary duty of care and must do what is reasonably practical to ensure the health and safety of their workers, including when allowing workers to work from home. So what can employers do? Well, they should ensure their policies for working from home are up to date and include consideration of the following. Is there a dedicated workstation? Are noise levels appropriate? Is the lighting adequate? Is the working position ergonomic? Having the worker provide a photograph of the proposed office area is a good start to identify any risks or hazards that may exist. And it may also be an effective way if you wish to consider the effectiveness of a workstation to go out and inspect and conduct a risk assessment. Once the risk is identified, any risk identified, the employer should take steps to minimise or eliminate those risks.
Question 4, and we'll steer away from offering any sort of workplace health and safety advice, but it's talking about the OHS Act and the reasonably practicable clause. I suppose we should tie that into the duty of care. So the question is, how good a defence is it for a PCBU in the event of a claim?
Well, and you've rightly pointed out, Tim, OHS is expressly excluded from common law, but the principles are similar. It all refers to the objective test of the employer must meet the standard behaviour expected of a reasonable person in their position. And the guiding principle of the Workplace Health and Safety Act is that all people are given the highest level of health and safety protection from hazards arising from work so far as is reasonably practical. And in terms of deciding what is reasonably practicable, you're looking at the likelihood of the risk occurring, the degree of harm it might result in, what the person concerned knows or ought to have reasonably known, and the availability of suitable ways to eliminate or minimise the risk. If the risk is particularly severe, a PCBU will need to demonstrate that cost safety measures are not reasonably practical due to their expense, and that other less costly measures could also effectively minimise the risk. So how good of a defence can really depend on if the employer has taken the steps that are both reasonable and possible to minimise or eliminate the hazard or risk.
Thank you. The last question on notice was to do with misconduct, and misconduct comes up in the statutory phase as a provision in the Act on serious and willful misconduct, which can prevent a claim from being accepted at that level. But can you talk about how it factors into the damages phase? Yeah,
absolutely. And just to touch on what you've just said, Tim, misconduct is absolutely governed by Section 130 of the WCRA. Injuries are not compensable if the injury is caused by the worker's serious and willful misconduct, unless the injury results in death of over 50%. The WCRA actually does not define serious and willful misconduct, but President Hall analysed the phrase serious and willful misconduct in Australia Meat Holdings and QComp, where he concluded that the inclusion of the word "and" meant that the phrase is used in conjunctive sense, so that the misconduct must be both serious and willful, and the requirement of the misconduct must be willful and adequately protect injured workers who might otherwise lose everything because of a momentary lapse of carelessness. And there is a case out there, and I won't go into any detail, but you can have a look at it if you like. One Steel Recycling and Workers' Compensation Regulator. Now, what I would like to leave with respect to that question is this. It is notoriously difficult for employers to successfully defend a claim using those provisions, as courts and tribunals set a high bar for the relevant conduct. At common law, you would see misconduct more factored into contributory negligence, so where the injured worker has failed to take care for their own safety.
Okay, I think we've hit time actually. So thank you. Excellent answers to some excellent questions. I'm very sorry if you've put a question online during the course of the presentation we haven't got to it. I apologise. We've just run out of time. So thank you very much, Angela, for presenting. Excellent topic today. Thank you, Elise, from our comms team, for organising all this. As mentioned earlier, this session is recorded and will be sent out to you shortly and uploaded to the WorkCover Queensland YouTube channel, where you'll find all our previous webinars in a dedicated playlist. We will also gather your feedback on this session via a short survey. If you're interested in attending more of our webinars, keep an eye out on your email, LinkedIn, and the events page on the WorkSafe Queensland website. And that's all from us here today at WorkCover Queensland. Thank you so much for listening in. We appreciate you taking the time to join us.